All rise. Oh yay, oh yay, oh yay. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Good morning. Please be seated. Good morning and welcome to the 4th Court of Appeals. We have one case on the docket this morning. It's cause number 04-20304CV, 1776 Energy Partners, LLC, and 1776 Energy Operators, LLC, versus Marathon Oil EF LLC and Marathon Oil EF2 LLC. At this time, I'll ask for announcements from the counsel for the parties. First, counsel for 1776. Are you ready to proceed?
Yes, we are.
Very good. And counsel for the Marathon Oil parties, are you ready to proceed?
Yes, sir.
Very good. Will either of you split your time with any of the other lawyers on your side?
They are.
Very well. Then the parties will each have, oh. You're all alone over there, Mr. Brennan. Very good. Then each of you will have 20 minutes to present your argument. And then Mr. Drennan, on behalf of 1776, you'll have 10 minutes for your rebuttal. With that, the court is ready to hear from the 1776 parties. You are welcome to bring your water to the podium and proceed.
You've been doing this 30 years, you still get nervous in front of an appellate court, which is always lovely. May it please the court. My name is Rodney Drennan. I have the honor of representing 1776 Energy Partners, LLC, and 1776 Energy Operators, LLC in this case. This case is spawned by an attempt by Marathon Oil, and I'm going to lump them together for initial purposes. There is a period or a point in the summary judgment argument where it's very important that they're separate because the JOAs are with different entities. So, but for the initial part, it's going to be 1776 and it'll be Marathon. This case spawned from an attempt by Marathon to grab a larger percentage of a working interests in something called the Culbertson 2H, 3H, and 4H wells. And it is governed by something called the Culbertson-Hughes JOA. The issue here is, and I'm sure that the justices have now become well-versed in oil and gas law with regard to these issues, and I'm not going to repeat all of that, is that in the working interest, the JOA is the controlling document always. The key is here, which is unique, is that there are separate JOAs for separate wells, including Bordowski is a separate JOA. And then there is something called the Longhorn JOA, which covered a number of wells. Those are all separate contracts, actually with different parties, and a few of them going forward. But they all have been combined into this case to basically by Marathon in an attempt to state that that is one debt. And that's something called cross netting. In other words, where the individuals who are owed a debt don't take an offset, they simply take money from one contract and then apply it to the debts allegedly under another contract.
When this case was submitted to the jury, did you have a breach of contract claim asserting that?
We did. We ended up with a breach. We asked for an anticipatory breach of the contract. The key was, Justice Watkins, is that when we asked for a motion, we actually found out about this later. We moved to amend our petition to add a declaratory judgment claim with regard to cross netting. It was denied 6 months prior to the trial. That's part of our argument going forward, is that the jury didn't get the full picture of exactly what was happening in this particular instance because they did not have the ability to understand or know that they did not have, or cross-netting was not approved. In fact, Judge Wilson ruled in our favor in a deck action stating that there was no need for you to have had to, you were always available to go ahead, regardless if you owed another debt, that you could participate in the Culbertson-Hughes 2H, 3H, and 4H wells. That's very important here because the issue is what Marathon contended or what they planned, which you can see for is Mr. Brown's email, and it's on page 5 of our brief. They outlined a scheme in order to force my clients into a particular choice that they didn't have to make. In other words, it is admitted at that point in 2016, there were certain amounts of money that my clients owed the Marathon entities. Under Bordowski, they had failed to pay a certain amount of money.
What was the role that Mr. Brown had at Marathon?
He was one of the, he was the individual engineer who actually scheduled and suggested the schedules with regard to the drilling of particular wells.
So then you think he was a decision maker that could set the schedule for drilling?
Actually, he was one of the key people in the meeting at the time to do that. But the other key part here is that the individuals who could make the decisions, which were, I believe, a number of the Marathon executives that all testified during trial and were all cross-examined, stated yes, they were aware of this particular email, and yes, this is the course, a path that they decided to take.
How do you think that the email sets out, does anything other than restate the terms of the JOA?
Because it basically plans out a scheme to where they can, what he asked for is that they would go ahead and basically do what's called in the business a head fake. They would test our ability, and you justices or this particular court were involved in the Longview litigation. They would test our ability to figure out whether or not we had the available capital at the time. In fact, they have been told, my clients have been told, that there wouldn't be any drilling until the following year under the Culbertson Hughes. That's what they were prepared for. That's what they were prepared to gather money, and that they were prepared to do.
And we're talking in like the 2017 range?
Correct. So the email came out in October of 2016. And then in the 2017 range, that's when they planned first quarter. That's what we were told initially. That's when the next drilling phase would begin with 2H, 3H, and 4H.
But didn't Marathon already have a pretty good idea because of the Longview litigation of the cash position that your client was in? That it was, since y'all were so behind, is what the evidence shows, on paying certain debts. Wouldn't they have already had a pretty clear idea that maybe 1776 wouldn't have been able to make this cash call?
Well, oddly enough, 1776 had been able to generate funding, or generate, what the evidence would show is that they had available funding for this particular project. And why it was important, and that's what was Mr. Bobigan's testimony. And you can read it, I think, with regard to, and I have the Penn site, which I can flip to in a few minutes. But the issue is that Mr. Bobigan specifically said, I have the funding available and a funder available to pay the $4.5 million AFE. We're ready to go. But I need an assurance that you will use this money pursuant to this contract and only this contract going forward.
But Bobigan said, we've got the 4.5. Was 4.5 all that was required to be paid?
That's correct. Under the initial AFE for the Culbertson 2H, 3H, and 4H wells, it was a $4.5 million payment. We actually, the total debt allegedly owed at that time was roughly around $6.5 million. That's what Marathon is going to tell you. But the key is here is that we had that available funding. What we were worried about, Justice, is that if we gave the $4.5 million, Marathon, which they could unilaterally do, we were concerned that they would apply it to past debts. And then they would declare us, no matter regardless, a non-consent in the Culbertson 2H, 3H, and 4H wells. Think about it. They not only get their money with regard to the back debt, but they also get a 68% increase in the working interest because they could just declare us as in non-consent. That's why the assurance was so important. We simply asked, please provide us with assurances that you're not going to cross-net, which cross-netting was not permitted under any of the contracts, specifically under JOAs. And it wasn't submitted to the jury because we weren't allowed to amend our petition to go ahead and do that, is that under these JOAs, you had the ability, I'm sorry, if you have
No,
questions.
that's okay. You raised an issue before that I had a question about, and then we moved on to something else. We're talking about kind of the timing of
Sure.
amending pleadings. And I have one amended docket control order. It looks like it was signed by Judge Reyes on April 5, 2018. But it shows that by that date, that the deadline for designating experts had passed and
Right.
the deadline for amending pleadings had passed. This is a voluminous record. Can
Yes.
you provide a citation for an earlier DCO that shows when those deadlines actually were?
I can't do it for the Penn site, but that's not a question that I was prepared for, to be
Okay.
frank with you, Judge. But it's in the record. I guarantee that much. But the key was it was this. We continued to do discovery throughout that period. In fact, we took the deposition, and what really spawned this is we took the deposition of Lori Lewis. Lori Lewis is an individual who is the accountant. She was the person who testified with regard to the accounting and to the accounting issues with regard to what was owed or what wasn't owed by my clients. During her deposition, which now is into 18 or into 19, or at that point in 18, she testified that not only did my clients not owe them money, is that they owed us money. that Marathon Oil actually had been withholding $1.8 million in revenue from us. And it also, we were about down to $88,000 total because they were netting, cross netting. Now, one of the arguments that I saw that was brought up and to finish the thought is that it's at that moment, we realized they were cross netting. And at that moment, we went to amend immediately, provided new facts, provided new justifications with regard to all of these issues, fully argued this, and still 6 months prior, Justice, we weren't able to get that in.
So you didn't realize in 2014 and 2015 and 2016, when the math of the payments on Culberson Hughes and Longhorn and Bordowski, when that wasn't adding up, you didn't understand that they were cross-netting then?
We weren't paying attention because the whole point of it is that we weren't getting, when we go non-consent or when you do not pay your particular bills, JIBs under this particular instance, you don't get the accounting. So Marathon no longer provided us accounting. I know the argument. There are two they're going to make. One is going to say, look, in this particular motion for summary judgment, we said we were applying this account to this account. We didn't care because the whole point at that point was all it was liability. We were under the understanding with that partial motion for summary judgment that the only thing that they wanted to say was we were liable under the contracts because, and I can go into and I frankly don't want to waste the time. I think with regard to Mr. King's affidavit, I think it speaks for itself, is that they provided estimates only. This is an approximation of exactly what was owed.
On Bordowski?
Yes, on all of them.
But on Bordowski, that's a little bit of a horse of a different color.
It is.
Than Culberson Hughes and Longhorn, because they were operators on Culberson Hughes and Longhorn.
We were the operators on Bordowski.
And had you provided them the data that they needed to do anything other than
They did, but Mr. King never said that he relied on it. So that was the whole point with regard to the affidavit problem, is that it's a substantive problem and not as they claim an administrative problem. He didn't rely on it. That was the whole issue. Plus, he didn't calculate the interest. He didn't calculate. They calculated interest upon interest. If you read Lori Lewis's or Ms. Lewis's testimony, at that point, they had made mistakes in the accounting. She had done an approximation, and she said it was estimates only that they had provided. She had provided the actual material that had gone into the affidavit for Mr. King. We didn't know that at the time.
And tell me how that affidavit was used. Was it used at the summary judgment phase?
Exactly. So that was the only evidence that I know of that Judge Wilson could rely upon in order to put these numbers into that particular motion for summary judgment. It simply can't happen that way. The other part of it, Justices, is that this was the longest attorney's fees trial ever. The only issues that were allegedly left in plaintiff's case were attorney's fees because they've been awarded judgment under the summary judgment, and a declaratory judgment action with regard to particular issues that had already been decided by the summary judgment. They went 9 full days with testimony with regard to damages. We redid damages. They tried it by consent. They put on all of the evidence. We cross-examined Lori Lewis. We found out they didn't know any money at all. Back to cross-netting real quickly, because I am going to run out of time. The issue here is Marathon's going to get up and say, cross-netting benefited them. Cross-netting paid their bills when they weren't. In other words, we have the absolute right, or we should have the absolute right, to be able to pluck the money that they owed to us under Bordowski from the revenues that were coming from the Culberson 2H, 3H, and 4H wells, or actually it was 301H is where the revenue was coming from. The issue here is this: that's not their choice. What if, we can provide testimony with regard to these issues. That's what Mr. Bobbigan would have testified about if he'd been allowed to testify, is that we can take that money and we can invest it into another 3 or 4 wells in the Eagle Ford. At that time, you're looking to a 3-to-1 return, and the decline curve in a well at the very beginning, that's where you get all your money. We could have maybe invested in another well, invested in more wells with Marathon, or with regard to those issues but it's our choice, and then we could pay the debt.
But you just said we could have maybe invested in another well. I mean, I understand some of Judge Wilson's comments on the record to say that that was pretty speculative at the time, because I think the evidence demonstrated, and if you can point me to any other evidence in the record that shows that you did have the ability to pay, but I thought that the record demonstrated that 1776 didn't have the ability to pay.
Well, actually, Judge, it did. So this is even the more interesting thing about this. If you go through the actual negotiations all the way through, and all of those documents have been entered into evidence with regard to the email correspondence between the principal and Mr. Bobigan, they even offered at a certain point that they could get all of the payment in for all of the debt. If they would agree simply that this debt would be used and then we would get another financing to go ahead and pay this debt. Crickets. So there was offers, there was attempts, and please, if you get a chance, if you have any questions about this, is the actual testimony of Mr. Bobigan, who goes all the way through and he explains exactly how the financing worked. And we walked him right through all the email traffic. And that's what made this so frustrating, is that we just simply said, hey, if we pay this amount of money, we just want to make sure that you use it for the purposes and we're in good standing. Because think about it, those wells went on production, and those are some of the highest grossing wells in the county. So we lost the ability to participate without a 500% penalty on 2H, 3H, and 4H. And those are the issues that we could have used that money, Justice, to go ahead and pay back any type of debt that we owed. Again, back to cross-netting, is that we didn't have it's not their choice. It's our choice without a court order to what we do with the money that comes from a particular contract. Otherwise, Justices, you will have chaos, because that could mean that any company, any successor in interest company, any formally indebted company, then an operator could come in and say, no, they owe us this money from this deal in South Dakota. They owe us this money from this deal in Alaska, and they could just go ahead and grab the money and pay off that debt.
But just kind of as a general contract principle, I mean, the JOAs say y'all are obligated to continue doing these deals together as long as you essentially can fund them, right? It seems to me that the JOAs are written such that if one party knows that the other party isn't going to meet its cash obligations, which it seems like 1776 was unable to do here, help me understand why it would be in anybody's best interest to keep doing these deals together and getting further and further behind.
Well, the issue was that we weren't getting further and further behind because they were cross-netting us, going forward. So they knew there was a pay stream. It's just we should be able to choose the pay stream. That's the key, is that in the contract, and it's very specific, the Culberson Hughes, the Bordowski, and the Longhorn JOA specifically says it is limited to the debts that are in this particular unit. And I can point you to it with regard to those issues.
But on that point, you didn't have a cause of action challenging the process of cross-netting in the court below, or did you? If I'm mistaken about this, please provide me your record sign.
So that's the issue, is that we weren't permitted, once we found out they were cross-netting, we weren't permitted to amend. But I will say this much, we did get a declaratory judgment from Judge Wilson that specifically said, you don't have to be in good standing in order to participate in the 2H, 3H, and 4H wells. Basically, if you had that, and that's where I'm going to, in my last 10 minutes, where I'm going to bring this home, apparently, is the issue is that the jury never heard that. So think about it. We look like deadbeats. We look like deadbeats in front of everybody. And yet we have financing. We have a commitment with another financier. We have, as far as email traffic, we have the testimony. The unrebutted testimony is that we had the financing available to participate in 2H, 3H, and 4H. Unrebutted. So the whole issue here is the jury never got to see, well, it would be a breach of contract if they didn't allow us to participate in the 2H, 3H, and 4H wells. They had to allow us. It's a breach of contract if they didn't give us reasonable assurances for performance. If I do this, will you do this? The simple, that is just black letter law with regard to anticipatory breach. And they wouldn't tell us. And they had already engaged in a scheme. And it's just laid out almost perfectly. And yes, there was all rights under the JOA. But the other part is, if you notice, Justice, is in the testimony with Mr. Brown, he states, but we didn't have to drill it. We could just head fake, get them to present the money, and then decide not to drill the wells.
But doesn't the evidence, I mean,
they eventually
did drill the wells.
They eventually did, but not on the same time schedule. So the whole key here is what they were trying to do was proof of funds. And look, I understand all about that, but at least tell us, have the integrity and have the wherewithal and follow the law and tell us specifically that we will be able to participate, but we still want to get this debt taken care of. Fine, you can sue us on that debt going forward. You can get a judgment against us. You could you have so many options after the fact going forward. If you didn't cross-net, you could put a lien on all of our wells. You could put a lien on all of our property with regard to those issues. But they chose instead to basically skullduggery to go ahead and try to pull a fast one, and we caught him. And that was the whole issue here. So the problem was that the jury and the jury charge. So we presented jury charges going forward with regard to all these issues. They were denied. The PJC wasn't even followed with regard to anticipatory breach or anything other issues. The problem is that the jury, I think, was misled. And I think that specifically, had they known with regard to that it would have been a breach of contract if we could not perform, that they would have found an anticipatory breach. They didn't understand the impact of exactly what that request was for. And by denying us the ability to do that with regard to it, it was preserved properly. I know they're going to argue a lot about waiver and preservation. We did proffers. We did objections everywhere with regard to the trial. It's full of it. We made absolutely sure our record was covered. And we can go through all of that later in the 10 minutes that I have left if you have any questions with regard to that.
And I realize I have asked you a ton of questions in your first 20 minutes. And so we can extend our time a little bit, because before you sit down, I'd like for us to take some time and talk about the numbers that are in the final judgment.
Well, I joke when I say this, and no disrespect to Judge Wilson, wonderful man, had a great experience in front of him, just not the result we wanted. But the key is that it's not, you can't do a choose your own story final judgment. You can't say, if the appellate court says this, then it's this. And if the appellate court says that, what if nobody appealed?
So then it was Judge Wilson who crafted this final judgment?
Oh, I didn't write it. I mean, frankly, Justice, yes, it is a solely wholly crafted judgment that took over a year to get from the actual date of the jury's verdict. So the key here is just, and I'm going to come back up for the last 10 minutes and I'll give you my prayer, but thank you for listening to me. It's been a pleasure. And I turn it over.
Really quick, before you sit down, I would like to just take just a few minutes and talk about these numbers. And we can, before Ms. Weber comes up. Okay, so to controvert the amounts that were contained in the final judgment, you have to point to evidence to show different dollar amounts, right? So the 2.058 million on unpaid revenue under the Bordofsky JOA, assuming we disagree with you on your legal theories, what evidence can you point to in the record, either testimony or an exhibit, that shows a different dollar amount for unpaid revenue on the Bordofsky JOA than the 2.05?
It is exhibit 126, I believe. It is the chart that was actually made by Lori Lewis, and it is used extensively in her cross-examination. So that's where you need to look. And I'm sorry that I would love to have been able to pull it out to you. But the whole point of it is that she did a flow chart which showed we didn't know any money at the date of the trial.
At her cross-examination at trial?
Absolutely.
Okay.
And that was the thing that threw us, is like, we retried a damage case, Justices, when allegedly damages were already fixed. So, and then you would not allow a jury question to go to the jury to determine exactly how much was allegedly not owed.
But wait, let's pull on that thread a little bit, because what Ms. Lewis testified at trial was that the final amounts owed were less than they were at summary judgment, because Marathon had gotten more information about the amounts on Bordofsky, and B, cross-netting had continued, and so 1776's liability had gone down.
Right.
Do you really not want credit for the amounts that were cross-netted?
And that's the issue. And I'll be frank with you. What I want is a new trial, because I want to be able to go back and say, look, if you hadn't cross-netted, because the other thing that she will also testify that we lost is we lost interest.
But you don't just want a new trial, right? You want to reopen the pleadings deadlines as well.
Absolutely. I want to be able to go to the jury in this particular case with the full arsenal of exactly what happened with regard to these issues going forward, and my expert. I mean, the issue that I really have here, and we'll get into the expert, I think that speaks for itself. That was hyper technical, and I think that my client should have been able to testify with regard to those issues. But yes, I want a new trial with regard to these issues, because one, frankly, the decision by Judge Wilson with regard to the final judgment, it's untenable. It's not accurate. There is no monies owed currently. One of the reasons that were interesting enough is that there was no bond paid in order to file this, because it's only attorney's fees. And we can get into attorney's fees later, but that speaks for itself too. But those are all great questions, Justice Watkins. But that's what I'm saying is, I believe that if you provide us with a new trial, which I think you really should, only because of the Supreme Court has stated you should try all of the claims together that are interrelated. It's particularly after we found out with certain information that was available after with these depositions going forward, is that the pleadings, it would have been a simple process. The pleadings would have been reopened. If any other depositions or testimony had been done, we had 6 months to do it. I mean, it's not like trial was tomorrow. It's not like I asked 7 days prior. And I realize that there is a, pleadings deadline and everything else. But the key was that this case dragged on forever with regard to those issues, and we were still taking depositions going forward. All right, my time is up. Thank you.
Thank you.
May it please the court. The court should affirm the final judgment in this case because it reflects a proper resolution to the actual contract claims between the parties, and 1776's various challenges are baseless and are wholly divorced from the record and the actual proceedings below. The contract disputes between the parties at their core are straightforward. 1776 did not pay sums that it was contractually obligated to pay under the parties' JOAs. The trial court resolved some of the claims on summary judgment, and then it tried the remainder, and the final judgment awards contract damages and a declaratory judgment regarding ongoing contract rights to Marathon. 1776's complaints about the process and the judgment seek to avoid the consequences of its own actions, both in business, in the wholesale default under their contractual obligations, and in the conduct during litigation where things simply did not get filed, didn't get pled, didn't get advanced. Now, because there are so many different procedural challenges, today I want to be helpful to the court to try to set out some what I think are some kind of guardrails to help you to advance the case to ultimate resolution. And to that end, I think, if I may, there are 3 areas that I'd like to give some clarity that I think are important. First, what are the actual contract claims between the parties? Second, what was the MSJ proceeding? Third, how did we arrive at the final judgment? What does the final judgment do? So, because there isn't any need for things to be more complicated than they have to be here. So regarding what are the parties, what are the actual claims? And to understand what the actual claims are, it's important, and Justice Watkins, you correctly identified, for some of the JOAs, Marathon is the operator. For some, 1776 is the operator. And so 2 important concepts. One is that money flows in both directions. Money and financial obligations flow in both directions. Where Marathon is the operator, they pay the bills, they send out joint interest billings or JIBs to 1776 to pay for the pumpers and the transportation, whatever the expenses are. And 1776 is supposed to pay back, to pay the JIBs, and then revenue is dispersed. So revenue goes in both directions and JIBs go in both directions. That's one concept. Another concept is that it changes every month. It is never static because hydrocarbons come out of those wells every day. The numbers are never fixed. They are always changing. There isn't some bobbing and weaving and, oh, we're bait and switch. This is the nature. They are today. Today, hydrocarbons are coming out of those wells, and the dollars as between those parties continue to change every day. During this time, when 1776 was in wholesale default, they were not paying the JIBs that Marathon sent for the properties that Marathon operated, and they were not disbursing the revenues to Marathon for the properties that 1776 was operating. Before this suit was filed, that debt by 1776 to Marathon totaled $6 million. It totaled $6 million before suit was filed.
And you're talking like in the 2014 time range?
I'm talking about in 2017 before the lawsuit was filed. In 2017, before the lawsuit was filed, we were at $6 million. That was the height. That was the largest debt. There was testimony. That was the highest debt in the entire Eagleford field for Marathon was 1776. And because of this other litigation, there's no end in sight. So Marathon started cross-netting, and there is nothing scary and nefarious about it. Cross-netting just means I'm supposed to pay you $100,000, but you owe me $200,000. So I'm going to hang on to that $100,000. And now you only owe me $100,000.
What does the
It-
record show about when cross-netting started?
Cross-netting started even before the lawsuit began, and cross-netting, and that leads me to the second big thing I want to talk about. So that's the background of what are the claims. What that this goes back and forth, what cross-netting does, and the fact that it changes every month. Super important, those two concepts. Then we get to the summary judgment proceeding. By the time we filed our motion for summary judgment, the lawsuit had been on file a whole year. It had been on file a whole year. Litigation had happened. Discovery could go forward. Depositions could take place. All of those things where you find out about your claims. A whole year in, we file a motion for summary judgment, and everything about the motion for summary judgment was explicit that the dollar numbers that we were seeking summary judgment on were the result of cross-netting. It's explicit in the declaration of Mark King that we attached. And Justice Watkins, you've asked a lot of, where is this in the record? Where is this in the record? We attached all these things as appendices to our brief because we are not afraid of them, because they are there, because this evidence appears, and we're not afraid of it because we did the right thing. So in the Mark King declaration that is attached as Appendix 4 to our opening brief of appellees, in paragraph 5, it says, Marathon is netting revenues accruing to 1776's revenue interest against the amounts 1776 owes. So when Mr. Drennan says to you that they didn't know there was cross-netting until 6 months later when we took Lori Lewis's deposition, that is not true, because it's on paragraph 5 of the Mark King declaration. It's also in the motion for summary judgment. It's also expressed in the proposed summary judgment order that we submitted to Judge Wilson. It's also expressed in the summary judgment order that Judge Wilson signed. We filed a motion for summary judgment saying, Judge, give us summary judgment on our breach of contract claim for these damages. Here's a declaration with documents attached, with summaries attached of the accounting. We had a Mark King declaration about the jibs and what was owed under the jibs. We had a Lori Lewis declaration about the unpaid revenues, because those are two different sort of accounting accounting exercises. What do you owe on the jibs? What do you owe on the revenues? And then it netted out. And we asked for that net dollar number, summary judgment on that net dollar number. And what did 1776 do in response? They did not file the counterclaim or plead anything, Justice Watkins, that, hey, you can't cross claim. Hey, that's not right. Didn't do that. They didn't have an expert saying, hey, your numbers are wrong. And the thing as an aside, the reason Lori Lewis had to do an estimate at the time of the summary judgment is that they hadn't produced to us the accounting, because the revenue accounting, that's for properties that 7076 operates. So they've got those documents. We don't have those documents. So if they thought that Lori Lewis's numbers were wrong on the revenue end, those numbers came from them. And so it was in their hands. If they wanted to contest it, it was in their hands. They could have had an expert then. They could have had Mr. Bobigan. They could have had one of their accounting people. What did they do instead?
But let me interrupt you really fast. That's only on the Bordowski wells, right?
No, Your Honor. That's the whole. Now, the Bordowski wells are the ones that are where they owe us the revenue.
Right, that they are the operator.
Yes, the other ones are where they owe the jibs. But here's the thing. So the motion for summary judgment sought a net award through the cross netting. It sought the net award. It was clear on that. It was unambiguous on that. And what they said, 1776 concedes that it breached its obligations related to the Bordowski, Hans Rafter, Yarosanka, and more Hans units. That's at volume 2 of the clerk's record, page 325. Their summary judgment response. We concede we breached our obligations. And just as a little aside, Your Honor, this summary judgment response is filed on behalf of both 1776 partners and operators, both 1776 entities. And then it says collectively 1776. And then throughout, they just say 1776. And so what they say here, when they say 1776 concedes that it breached these JOAs, they're lumping both entities together. So the thing about, it's different entities, it was never litigated that way. That's another example of that the complaints to this court are divorced from the actual proceedings below. So when we moved for summary judgment and one Judge Wilson granted summary judgment, it was on the net dollars owed at that time. Now, I said before it was $6 million before suit was filed in early 2017. Now, by mid 2018, at the time of the summary judgment, because of cross netting, the $6 million was now $3.36 million. And that was the amount that the summary judgment granted. So Judge Wilson granted summary judgment, not on the entire case. The summary judgment does three things. First, it grants us those contract damages with a specific dollar number regarding the wholesale failure to meet financial obligations. Second, it grants us summary judgment, a declaratory judgment that 1776 is non-consent on the 3 new Culberson wells. But it reserves for trial, the third thing it does, it reserves for trial the adequate assurances repudiation contention, the shenanigans that Mr. Drennan described, the Brown email and, it was a head feint and a bait and switch in proposing the new wells. Reserve that, let them try that. So that's where we are in mid 2018. 1776 has never made a peep about cross netting is improper. It's explicit. That's where we are. That gets us to the third piece.
Before we move on from the summary judgment, and we'll have plenty of time to talk about the final judgment, you started out by saying that these numbers are never static, that the numbers are never fixed, that they are always changing. When you moved for summary judgment, did you think that it would dispose of the entire case and very quickly be converted to a final judgment? I'm having a hard time understanding why you would move for summary judgment on damages when the numbers really do fluctuate every month.
Well, Your Honor, because at some point you have to pull the trigger. There is never a moment when it's going to, there's never a moment where it's going to end. The numbers now are fixed. That's never going to happen. What we thought, we moved for summary judgment actually on everything save attorney's fees. What we thought would happen after the summary judgment was granted is that all we'd have to do is try our attorney's fees, which might have been able to do by submission, as often happens, and that would be the last little bit and we'd be done. But everything has been more complicated in this case than it needs to be. So when we moved for summary judgment, we thought, and the opening paragraph of our summary judgment motion says that if you grant this motion, all that's left is attorney's fees. But instead, we had another year of litigation on but wait, the adequate assurance piece, the repudiation piece, and during that time, during that remaining year, the numbers continued to go because every month it happens, and so then we arrive at the moment of trial. And so at that point, Marathon has an election to make. We have an election to make. We can try only our attorney's fees and defend against the 1776's contentions of the adequate assurance business and have a final judgment that reflects the dollars that are in the summary judgment, which at this point are obsolete. That's a year has passed. A whole year has passed. And this is an example. No good deed goes unpunished. Marathon did the right thing and asked the court to lower the damages, to remit, to reflect the current as of the time of the final judgment. And it was explicit everywhere that we were not putting this on. We were not trying this by consent. We were presenting these numbers to the court to allow a remitter to lower our own final judgment so that it would more accurately reflect the accounting between the parties as of the time of the trial. And so we went from 6 million before trial to 3.36 million at the time of the summary judgment to 1.6 million at the time of the trial and that's what's reflected in the final judgment. So now Judge Wilson made the decision that it was appropriate for the jury to hear the damages numbers because they were going to have to assign the award of attorney's fees, and the notion of results obtained, what was at stake, is germane to a jury's determination regarding the reasonable and necessity of attorney's fees, and that's why it was before the jury as opposed to just submitted to Judge Wilson. But the thing is that Mr. Drennan said, we tried a 9-day attorney's fees. No, we didn't. The bulk of that trial, the biggest dispute in that trial was their defensive measures, the repudiation, reasonable assurance contentions about the head feint. And Justice Watkins, those issues were tried. They don't need a new trial on those issues because those issues were tried. That the email, the testimony about about what offers they made, could they have done the funding? What were the funding proposals? Oh, it was a bait and switch. All of that was tried. All of it was tried, and the jury rejected it. The jury rejected it. The jury found no, Marathon did not fail to give adequate assurances. No, Marathon did not repudiate the contract. So the contentions of, oh, that was a bait and switch and we got ripped off and didn't get into the new Culberson Wells, those issues were tried and they were rejected by the jury. And so I think in tracking through what are the issues here, the claims, the summary judgment, the final judgment, there's a logical progression and they all reflect an appropriate resolution of the contract claims. I want to emphasize two additional points though. In tracking through and dealing with, and I know that this court, you have to address everything that's in the brief of appellants. You have to address all the issues that they have raised. And there are a number of issues that we have included in our brief. We've identified, pointing to the record, many of the issues, the bulk of the issues were never raised below. And waiver is something, it is very important to recognize in this case, waiver is not a hyper-technical or a tricky procedural default or a hyper-technical, and it's not us whining, because in many instances, these are things that we could have fixed if they had raised it earlier. Judge Wilson could have made something right if they had raised it earlier. For example, one of the complaints is, oh, our summary judgment motion was not sufficiently detailed that we were asking for an actual award of dollars. Well, on the merits, that's ridiculous. You read it, it's lengthy, it has dollars in it. What do you think the declaration of Mark King is for, if not to establish the dollars of it? Our proposed summary judgment order has dollars in it. So that's without merit. But it's also waived because if they had said that, if they had filed special exceptions in the trial court, we could have fixed that. So we would be prejudiced if this court says, oh, now we're going to reverse because it shouldn't have happened. So all of which is to say that we urge the court to find waiver where appropriate among the various procedural issues here. And the second point I want to make as my time winds down.
Very quickly before you move on to that, and I apologize, we can extend the time a little bit here too. If 1776 had been allowed to amend and to replead, what would you have done differently? Like what other steps would you have been required to take?
Well, first, from a procedural standpoint, what 1776, what they did was 6 months, half a year after the summary judgment motion that said cross-netting. 6 months later, 5 months after the pleading deadline, which was in June of, the pleading deadline was in June of 2018. And the citation for that, Justice Watkins, is volume 9 of the clerk's record, 279. In June of 2018 was the pleading deadline. In November of 2018 and then in November, they filed their motion for leave to file a third amended petition. And the motion for leave to file the third amended petition added the cross claim in the complaint about cross netting and sought to add IBM as an additional party. That's in the same pleading. They didn't file a motion for leave to add a counterclaim. They filed a motion for leave to file the third amended counterclaim. It didn't parse out IBM as a new party versus the cross-netting complaint. They were in the same pleading. Judge Wilson couldn't go through and say, okay, you can add paragraph 4, but you can't add paragraph 6. You can add the first part of paragraph 11, but not the second part. It was never presented. Not only was it a day late and a dollar short, it was never presented to Judge Wilson to add just a cross-netting counterclaim. And what we would have done different, that would have been a completely different trial. What we were trying was attorney's fees. I mean, it was already set in stone. That would be the summary judgment order already established. Trying cross-netting would have undone all that. It's like a wayback machine, going back and pretending that the whole first year and a half of the litigation didn't happen. And this is an instance of just procedural default. They didn't do it. It's not we want a new trial, we want a mulligan. You said it yourself, we want the pleading deadlines all gone. We want to start from scratch. The lawsuit was filed in March of 2017, and we want to turn back the clock to then. And we want to do everything different, because I would have filed a different answer. I would have filed a different pleading. I would have given an adequate expert designation. I would have responded to the order compelling me to give an adequate expert designation, even though I got a second chance and a third chance, and I actually would have done it instead of blowing it off. I want a chance to do that. But if I may make one more thing, there is no error in this final judgment except for our cross point. I don't want this to get lost in the shuffle. The cross point is there's a single bit that Judge Wilson gave to 1776, and that was the declaratory judgment. And the declaratory judgment exists only for the purpose of giving them $145,000 worth of attorney's fees. And the declaratory judgment that the court actually gave was it was a super narrow focused one that was never disputed and does not alter the relationship of the parties or resolve any justiciable controversy on a going forward basis. And so this court should affirm the judgment in all things, except reverse the declaratory judgment for 1776, reverse and render that to take away the award of attorney's fees to 1776. That's a tendant that exists only because of that unnecessary, undisputed declaratory judgment. If the court has further questions.
I do. Okay, so let's spend just a few minutes, and I understand that Mr. Drennan had a few minutes, and so we'll spend some similar amount of time here looking at the amounts in the final judgment, and help me understand, when this lawsuit was filed, you were the plaintiff. You had the burden of proof to prove both liability and damages. The damages had changed since the summary judgment. Why didn't you ask a jury question on damages?
A couple of reasons. Because we already had summary judgment on it.
But you admit that the numbers had gone down.
And so we gave it back. Now, if it was in the other direction, if the damages had gone up, that would be inappropriate. That we absolutely should have tried it if the damages had gone up. If we owed more money, if it was going from 1.6 million to 3.36 million, absolutely. We would have had to try it, because that would have been a fact finding to increase the damages. Absolutely. We either would have needed to have another summary judgment proceeding, or we would have had to try it, but it wasn't. We had a judgment in hand for $3.36 million. And we did the right thing to give some of it back, to lower that amount. And those numbers you asked Mr. Drennan, where did those numbers come from? Again, we're not afraid of it. This chart, we attached it to our appendix. I think I even put in my brief something about that you have to put it up to 200% to be able to read the numbers on the screen. This is plaintiff's exhibit 068A. That was the subject of Lori Lewis's testimony a bunch at the trial. We attach it. All these numbers are right here. It is not true when Mr. Drennan said to you it's that we owed them money, that there was a net we owed them money at the time of the trial. That's not true. These numbers, the numbers that are in the final judgment are right here in this exhibit. We did the right thing by not taking more than we were owed at that time. Judge Wilson did the right thing by allowing that remittiture and putting those modified numbers in the final judgment. And he did the right thing. Frankly, he called their bluff by putting in the alternate bit in the final judgment that if this court thinks, oh, you know what, the Lori Lewis's testimony or whatever the evidence at trial, okay, it was disputed. We don't know exactly how far it went down. Maybe there's fine. Slash that one out, bring us back to where we were at the summary judgment.
But wouldn't that be wrong under the logic that you just, because cross netting had been applied in the meantime?
Well, you know what, Your Honor, but even the day after, the day before and the day after and continuing to today, it's always going to change.
But then how can you get judgment as a matter of law?
Well, it was a snapshot in time. If the case had been tried just attorney's fees, if it had been tried just attorney's fees, as we anticipated, and then there was a final judgment for the summary judgment dollars and then an award of attorney's fees, whatever, 90 days later, at that point, it would have been inaccurate. Next week, it would be inaccurate. Every day, hydrocarbons come out of those wells. And to this day, I couldn't tell you today what the accounting is as between these parties, but they are continuing in business. There are jibs and there's revenue going in both directions, even to today. So then, which adds another question. If you remanded for a new trial on damages, what would it be? Are there any damages today? We're now 2 years from the judgment, 3 years from the trial. What is it today? It could be that it's zero, that we're even Steven and everybody's paying their, everybody's current 1776 is out of the hole and they're now in better financial. We don't know. But the point is that at the moment it was tried and there was no error in doing that process against, back to my first point, against the claims that were actually presented in the case. And we urge the court to affirm the judgment in full, except for the cross-claim, the 1776 declaratory judgment.
See how fast I can talk in 10 minutes then. May it please the court, opposing counsel. You were a wonderful, take on this trial by a person that wasn't there. And I was the trial lawyer, so I was actually there. Ms. Lewis, if you would please go back, when you go back to render your decision and look at the cross-examination of Lori Lewis. Ms. Lewis testified that the delta change, in other words, the acceptable error in her calculations is $500,000. So she claimed that we owed allegedly $1.586 million, but it could have been $1 million. It may have been a little less. The problem is Judge Wilson replaced himself as the trier of fact. And he can't do that. That is without question with regard to those issues.
Now, Ms. Lewis was really, in her testimony, she was relying a lot on plaintiff 68A, correct?
That's right.
Was that the number that?
It was.
Okay, that was I just wanted to make sure
that's right.
We're on the same page. So I still have, and I understand, what she said about, the $500,000 margin for error. Show me where in plaintiff 68, the $500,000 margin for error matters.
It would be because opposing counsel just stated that Judge Wilson relied upon that document to put into the number at the end of his remitter, I guess is what it is. It's actually an additor. But the issue is that he relied on it. So the problem was he replaced himself with the trier of fact. I elicited the testimony from Ms. Lewis, and she admitted under oath that it could be as low as this or as high as that. That's a jury question. That's a decision for a jury to make, to judge her credibility and as to whether or not that those are the issues. That was taken away from us. They tried a 9-day case. Yes, she said mostly it was all of their case in chief. It's 9 days of attorney's fees, and you're going to go into the entirety of the case so that the jury can understand that you won $1 million in attorney's fees?
But we also had your questions 1 and your questions 4.
Correct. But the issue is this, Chief Justice, these are good questions. The 3 things I want to address with you very quickly was, remember how you said right in the beginning, you're like, well, look, you didn't have the money. That was clear. You effectively did what we were worried the judge would, the jury would do, is you're a deadbeat. But we went from 6 million when the case was filed to 3 million by the time the summary judgment came along in a year, to 1.586 million with regard to those issues. Now, also look very carefully. I implore you, please read that cross-examination. 068A, if you go down the columns, it says Longhorn, Bordowski, everything else. We're net positive on Culbertson Hughes and Longhorn. That's money that we could have chosen, that you pay us, that's fine, and we could have chosen to pay you with that. So they took our choice away.
Okay, so the chart that kind of sums it all up,
Correct.
that's under the Longhorn kind of section of 68A. It says 93,000 credit on Culbertson Hughes, $469,000 credit on Longhorn. That doesn't clear your debt, right?
No, but the key is that
How would that have allowed you to opt in to Culbertson Hughes 2H, 3H, 4H?
Because with regard to with 2H, 3H, and 4H, that would have made us current. And that we would have been able to go ahead and then participate in that well. Remember, the JOAs are separate. So just because you're not current on a Bordowski JOA doesn't mean you can't participate in the Culbertson Hughes, excuse me, I'm going to fall down, the Culbertson Hughes 3H, 2H, 3H, and 4H wells. We knew they were going to be remarkably profitable wells. There's no testimony that says, in fact, all the testimony with regard to the Marathon folks, it's going to be remarkably profitable. So that was the whole issue here. And the key is that, so we owed money on Bordowski at the time of the trial with regard to those issues, but that's what we wanted assurances of. If we paid the amount of money that we now overpaid, by the way, with Culbertson Hughes, that you would not take the money that we gave for the Culbertson Hughes with regard to those issues and apply it to the Bordowski, because you cannot do that under the JOA. I think it's really interesting is Ms. Weather says, well, of course we did that. It's only fair, but it's not what the contract says.
But did you have a cause of action at the time of trial that asserted that cross-netting as a practice was violative of your JOA?
We tried, again, with regard to, as soon as we found out about those issues. By the way, the netting portion of Mr. King's affidavit, it's not mentioned with regard to any of the issues inside of the document. The motion for summary judgment specifically only asked for relief regarding liability and not damages. Read the prayer for relief. That's important. The key is that we weren't paying attention to this with regard to those issues. It's not our fault because we didn't have to. So the whole issue is that they have to provide summary judgment evidence that is accurate enough with regard to those issues. And he says we're through netted revenue. Netted from what? He didn't say Culbertson Hughes is netting to Bordowski. He didn't say Bordowski is being netted into any of these issues. We had no idea. He could have netted it from one of the wells that were actually in the Longhorn wells. Longhorn has Hans Sauer, Yanka Sauer as well. And he could have said, okay, we're netting those wells. That's it. But that's in the same JOA, and you can do that. Internally to a JOA, you can net. So he didn't say, oh, we're cross-netting. That's the key here. They want you to say, well, they were on notice. He said he was netting. Well, that's right. They can definitely net under the Longhorn JOA, but they can't net Culbertson Hughes to these issues. Going forward, we didn't waive anything. I mean, we proffered testimony with regard to these issues. And Justice Watkins, you asked some really good questions about timing and everything else. Why did you wait? Why the DCO is up with regard to these issues? We tried to get depositions. We tracked with regard to these issues. We did it by agreement. They provided Ms. Lewis twice, and that's after both before and after as a corporate representative with regard to those issues. And only then could we have amended that petition. The Supreme Court is really clear here. Regardless, even if you have a DCO with regard to these issues, they have to show some surprise and some prejudice to allow us to go ahead and amend those issues. I implore you, find it. It's nowhere to be found. They didn't raise any prejudice that was real. They didn't raise any surprise. And they didn't raise, that is incumbent upon them to do so.
But you were asking to add a new party.
But the
too.
thing was, is that we asked it separately as well for a new party, but they could, Judge Wilson could have easily said, I'll deny it with regard to adding IBM, who apparently had all of their documentation. That was the reason we had to add them, because we couldn't get numbers. We never knew, by the way, what the numbers were, because again, once you go non-consent, or once you're out of what we call out of contract with regard to, you cannot get financial information from Marathon. We didn't have a clue what they were doing. That was the whole point of the netting thing. That's why it doesn't make any sense to us. If we had seen that they were taking Culbertson Hughes dollars and applying it to Bordowski money, it would have been great. We would have known, but we didn't. We couldn't, because they wouldn't give it to us. But the issue here, Judge, is 6 months prior to trial. There would be no prejudice. I don't think there's a case out there that says that if it was more than 30 days, there's 7-day amendments that are appropriate in certain instances with regard to these issues. I'm not saying it's one of them, but the timing here, in order to get this right, in order to put everything before a jury, it prejudiced our ability to come in going forward. And that's the big key here. Look, proving an anticipatory breach or proving the lack of assurances is hard enough. But not allowing the actual jury instruction to get to the jury with regard to what we proposed going forward, it looked like that they could cross net. It looked like we were in debt with them under the Culbertson Hughes when we were saying we weren't in that much debt. And we weren't. We were certainly not at the time of the summary judgment, $3 million in debt. At the time of trial, we weren't even close. In fact, all of the debt was Bordowski. So at the time of trial, we were actually in good standing under Culbertson Hughes. So the jury never understood or couldn't understand without the instruction that we would have proposed with regard to the Culbertson Hughes wells, is that it's a breach if you take the money slated for the Culbertson Hughes wells going forward. And if that had been provided to the jury under the information they had with Mr. Brown and all of the other Marathon individuals that testified that backed up Mr. Brown, they all admitted it was a head fake. It's remarkable. You can't practice this way. You cannot condone that type of behavior. It's Machiavellian and it's hardball. I mean, absolutely. But when it breaches into, when you give a partial disclosure, you'll read this in our briefs. When you give a partial disclosure with regard to the facts of the drilling and everything else, you have to give the full disclosure as to why. When we ask you why, and if you want to do that, you had to ask us why. That would be the inducement. Those are the issues, Justices. It's a true pleasure, unless you have any other questions, to talk with you today. It's my first time in front of the Fourth Court of Appeals. However, it turns out I appreciate the experience and the time, and so does my client. So, but again, I implore you, we need to do this again. This needs to be done right. I appreciate it. Thank you. Thank you.
Thank you both Mr. Drennan and Ms. Weber for your excellent argument today. Today's arguments will be archived on the court's YouTube channel. And with that, the case has been submitted and an opinion will be forthcoming. The court stands in recess.
All rise.